Hi, everyone. Thank you for joining us today for Constangy's webinar, Disparate Impact Theory, Dead, Dying, or More Important Than Ever. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenter may not be able to address all of your questions during this session, but we encourage you to reach out following the presentation. Her contact information will be included in our post-webinar follow-up email. This program is approved for SHRM and HRCI credits. We'll be sharing those codes at the end of this presentation, so please stick around in order to get them. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenter, Cara Crotty.
Thank you so much, Victoria. Hello, everyone, and welcome, and thank you for joining us for today's webinar, Disparate Impact Theory, Dead, Dying, or More Important Than Ever. And hopefully it's obvious that's a rhetorical question because I doubt we would have too much interest in a presentation on a topic that had no relevance. So hopefully by the end of our session, I think you will see why understanding disparate impact theory is as important as ever. I am Cara Crotty, a partner in the Columbia, South Carolina office of Constangy, and I co-chair our practice groups on EEO contractor compliance and DEI compliance. I'm also an employment litigator, and I have spent a significant amount of my career handling issues involving disparate impact theory. So this is definitely a topic that is near and dear to my heart. So thank you again for joining us. Just a couple of disclaimers before we jump in. First, this probably goes without saying, but this presentation is for educational purposes and is not legal advice for any particular employment decision or situation. Second, this is a nonpartisan discussion. As you'll see as we go through here, if you don't already know, the federal government has adopted a significantly different enforcement position than in the past. And the Department of Justice has offered a new constitutional view of disparate impact theory. My goal today is to explain the administration's position and what it means and how it will impact employers. But whenever I do a presentation that involves any administration's different stances or opinions, I try to keep the politics out of it and just impart the information. So I will continue to do my best to do that today. And then finally, just a reminder that the requirements in various jurisdictions will be different. And this is definitely a rapidly changing area. So the employer should be sure to confirm the laws in the jurisdictions where you have a presence. And I know we have a few more people that have signed on since Victoria did the introduction. And I know the most frequent question is, will we get a copy of the slides? So the answer to that is yes, she will send out both the recording and the presentation probably in a day or so. So you will have access to the materials. All right, let's start. Oh, and I also meant to say, Victoria did encourage you to put questions in the chat. Please do so. I will save those towards the end. Just I want to make sure that I have time to get through everything. And hopefully we'll have time at the end to address some questions. But if not, I will follow up with people that I'm not able to address, for whom I'm not able to address the questions. So, all right. Let's start with the practical question that's driving our discussion here, and that is, has disparate impact theory become irrelevant? The short answer is no. The risk around it has certainly changed, but disparate impact theory has not disappeared. Federal enforcement priorities have moved away from disparate impact theory, and that's certainly important and significant to us as employers. But at the same time, Title VII still contains the disparate impact framework. Courts are still applying it, and private plaintiffs are still invoking it. And on top of that, we have state laws that are addressing disparate impact, especially in the area of AI, and AI employment-based tools. So that's adding another layer because we see more and more rules around bias testing or algorithmic discrimination. So we're going to begin today with the legal foundation of disparate impact theory, because I think understanding that or ensuring that we understand that will give us a better framework for discussion of the current issues. We will examine the developments within the Trump administration, and we will separate what those developments change from what they do not change. We will also look at the state law and artificial intelligence landscape. And then finally, we'll finish with hopefully some practical compliance strategies for employers to consider now. And the theme that I hope I can carry that resonates throughout today's session is that deprioritized federal enforcement is not the same thing as a repeal. And even if there is a federal repeal of disparate impact theory, would not eliminate disparate impact theory altogether, because as you'll see, we have state law requirements to keep in mind. So the first section today is about the foundation of the disparate impact theory. Where does it come from? So quick background or review regarding what disparate impact means. So disparate impact addresses a facially neutral employment practice that disproportionately affects members of a protected group. Typically, well, almost always, it's going to involve a policy that is written in neutral terms and applies the same way to everyone. So the issue is whether or not that policy or practice causes a legally significant disparity for members of a protected class. And unlike disparate treatment discrimination, proof of discriminatory intent is not a requirement, not even a part of the analysis. We don't need any discriminatory intent to have to base a claim for disparate impact. And I think the examples on the slide here are pretty familiar. We could have a practice such as a hiring test or education requirements for a particular job, our criminal history screen, physical ability standard, and now, of course, we're seeing AI screening tools. None of these practices are automatically unlawful. But if there's a disparate impact caused by one of these practices, then the employer is going to have to justify its use of it. It's going to have to show that there's a legitimate business reason for using a policy, practice, or a tool that has that statistically significant disparity on a protected group. And I thought it would be helpful here to give you a basic example of how disparate impact plays out or kind of the math behind it. So I have a very simple hypothetical. So we're going to assume that we have an employer who hires 5 men and 5 women. You can tell I'm starting with very easy math. 5 men, 5 women get hired. And you look at those numbers, those raw numbers, and the result is evenly divided. So you think, well, we have the same number of hires for each of our protected groups. So clearly there's no problem. Well, let's add another layer here and add information about our applicant pool. So let's assume for the same hypothetical employer that they had 5 male applicants and they hired all 5 of them. And at the same time, they had 100 female applicants and they hired 5 of them. So the males, the selection rate for men, 5 out of 5 is 100%, compared to the selection rate for women, 5 out of 100 is 5%. So even though our raw numbers of hires, 5 and 5, were equal, you can see the selection rate for our 2 groups is very different. And that's where disparate impact theory comes in. It's looking at the selection rates of our different groups. And obviously that's a pretty stark difference. It's not typically not going to be quite that dramatic. But any kind of difference in the selection rates that is statistically significant, which basically means it raises an inference that it's not likely to have occurred by chance. That's what statistical significance basically means. So when you have that type of difference, it's a warning signal. It is not a conclusion that discrimination occurred. You still need to ask a lot of questions about the data. Did we look at the right applicant pool? Do we have the right comparators? Is the sample meaningful and statistically, large enough and practically significant? A lot of ways to drill down into the data that is used in your adverse impact or disparate impact analysis, because the numbers alone, without looking at those details, can be misleading. But that's the general gist of how we look at disparate impact. And that focus on consequences or outcomes of our policies rather than discriminatory intent comes from the Supreme Court's 1971 decision in Griggs versus Duke Power Company. This is really the origin of the federal disparate impact doctrine. So think back to the early 1960s, even 1950s, before Title VII was enacted, before race discrimination was unlawful. At that time, Duke Power had restricted certain departments to just white employees. It was not unlawful at the time. When Title VII was enacted in 1964, Duke Power changed its policies and required applicants and employees to have a high school degree and to meet certain test scores before they would be transferred or hired into those departments. So facially neutral now. We're not excluding people on the basis of race, but you got to meet these requirements before you would be considered or eligible for selection. So they were facially neutral, but they had a disproportionate impact on Black employees and applicants because individuals at that time, Black individuals, had a harder time satisfying those criteria, generally due to the past effects of past discrimination. So the case made its way to the Supreme Court, and the court found that the diploma and the testing requirements didn't have a sufficient relationship to the successful performance of the jobs for which they were being used. There was basically no evidence that the degree and the testing scores really predicted who would be good employees in those jobs. So the court held that Title VII prohibits practices that are fair and neutral as written, but have discriminatory impact or effect when they're not related to job performance. So the two main takeaways from Griggs is that not every disparity is unlawful. Again, it's tied back to job relatedness. And also the big takeaway is that even a well-intentioned employer can face liability under the disparate impact theory because motive doesn't matter. It all goes back to the outcome and the impact of those policies and practices. Kind of the next step along the timeline for disparate impact was the development of the Uniform Guidelines on Employee Selection Procedures. The federal government, federal agencies got together and came up with this framework to provide guidance for employers around their selection processes. So this was adopted by the Department of Justice, the Department of Labor, the EEOC, and a few other federal agencies. And the guidelines basically addressed tests and selection procedures that are used for hiring, promotion, retention, really any kind of employment-related decisions. And this slide summarizes the core ideas or principles from the guidelines and really outline what employers should do or strive to do to ensure compliance and reduce their risk for adverse impact issues. One is monitoring selection procedures to see if there are if the outcomes are statistically significantly disadvantaging protected classes, preserving information about applicants and the selection rates. If there is a practice that causes adverse impact, investigating whether or not there's an alternative practice that would serve the same business purpose but have less of an impact. And then the 4/5 rule, you probably heard of the 4/5 or the 80% rule. It comes from the uniform guidelines. And what the 4/5 rule says basically is that a selection rate for if a selection rate for a group is less than 4/5 or 80% of the selection rate for the group with the highest rate, generally can indicate there's potential adverse impact there. So the 4/5 rule is really just intended to be a practical indicator that employers can use for kind of a quick assessment of potential adverse impact, but it's certainly not the end-all be-all way to analyze employment decisions and your practices. The courts have made very clear that typically they will rely on more sophisticated statistical analyses. And keep in mind, this was adopted back in 1978 when we were pretty much just using an abacus to do our calculations. Some of us had calculators, but we didn't have the super sophisticated technology that we have today that can do a standard deviation analysis, really in the blink of an eye. So that was used as a way to do some quick math. The next step was the enactment of the Civil Rights Act of 1991. So Congress amended Title VII to add the disparate impact burden framework to Title VII. So this is really critical because it's not just the Supreme Court saying Title VII says this. It's not just the uniform guidelines saying what employers should do. It's Congress amending Title VII to specifically codify disparate impact liability into Title VII. And this is why an executive branch policy change doesn't by itself remove a disparate impact claim from federal law. Real quickly, let me review the basic stages of a disparate impact claim as set forth in Title VII. First, the plaintiff has to identify an employment practice that is causing a disparate impact on the basis of race, color, religion, sex, or national origin. So it's not enough here for a plaintiff to just look at an employer's demographics and say, you don't seem to have enough women in your workforce. We think there's disparate impact. No, a plaintiff would have to point to a particular employment practice that is causing adverse impact in the selection process. The plaintiff does that, the employer then can demonstrate that the practice being challenged is job related for the position in question and consistent with business necessity. And so the evidence that the employer uses will vary depending on, what the practice is. If it's a test, they might have a validation study that's been done to show that this test does measure someone's ability to perform well in the position. If it is a education requirement, then they could have evidence to show that having this level of education or degree is more likely to make a person successful in that position. So it's all going to depend on what the practice is. But if the employer satisfies that burden, then the plaintiff can rebut that by demonstrating that there is another alternative available to the employer that would still meet their legitimate needs, but has less of an impact, less adverse impact, and the employer refused to adopt it. So the plaintiff actually has to come up with not just a theoretical possibility of an alternative practice, but an actual alternative that the employer could have used. So keep these 3 steps in mind because we're going to kind of revert back to them when we look at the Department of Justice's recent opinion, because again, the executive branch cannot eliminate the text of Title VII, but you'll see kind of what the DOJ's suggestion is around how this should be applied or interpreted. And then I also wanted to very quickly address some common misperceptions about disparate impact theory. If it's not something you work with day in and day out, it's easy to be confused about what it really means. And so before we turn to the DOJ opinion, I wanted to just kind of talk about some of these. And one of the first misconceptions we've already addressed, and that is that if an employer does not intend to discriminate, it's not going to face any liability. But that's confusing disparate impact with disparate treatment. Impact or intent is pivotal to a disparate treatment theory, but it really has nothing to do with a disparate impact claim. The second misperception is that if you have a policy and it applies to everyone, we don't have any risk. We're treating everybody the same. But again, like we talked about earlier, uniform application is not the issue. It's the impact of that standard on different groups. Again, the 4/5 rule, we talked about that. That is not really the standard that's going to determine liability under disparate impact theory. It's a basic screening tool, a rule of thumb that we can look at, but courts are going to want to delve deeper into the statistical significance. This fourth one, disparate impact, is only an issue for federal contractors. I definitely have heard that a lot since I've worked with federal contractors for many, many years on their compliance with Executive Order 11246. And federal contractors certainly had disparate impact more in front of mind because it was an essential part of an OFCCP compliance evaluation. That's what the OFCCP was looking for during a compliance audit. It was their disparate impact, typically in hires, promotions, terminations, or were there differences in compensation? But Title VII applies to all covered employers, so it's not limited to federal contractors. And obviously, as we'll talk about in a little bit as well, we have other federal laws and state laws to consider. And then finally, the issue around vendors. If we adopt or use a tool, especially an AI-related tool or screening device provided by a vendor, then the employer doesn't have any liability, right? That's obvious. That's not right. Using a vendor is not going to insulate an employer from legal liability if the tool or test that's being used has adverse impact. So sometimes an employer can potentially contract away out of some of that liability through indemnification provisions, but contract isn't going to change the civil rights statutes or prevent someone from filing a charge or a lawsuit against the employer. All right, next is our discussion of the recent shift in disparate impact during the Trump administration. So President Trump, I think it's clear to say, is not a fan of the disparate impact theory. And full disclosure, in case you don't know, that's not an AI-generated picture of President Trump, and it wasn't hard to get a stern picture of him, relating to not being a fan of disparate impact. That is the official presidential photo. But I think it it sits well in this slide with his disapproving glance or view of the disparate impact theory. So early in his administration, he issued an executive order entitled Restoring Equality of Opportunity and Meritocracy. And that executive order describes disparate impact liability as inconsistent with the administration's view of equal treatment and the order directs federal agencies to deprioritize their enforcement of disparate impact liability. It also directs agencies to review their existing regulations and guidance and any existing matters that rely on disparate impact. We recently saw the EEOC comply with that by issuing its new national enforcement plan. Their plan explicitly prioritizes intentional discrimination and states that the commission will not commence, develop, or continue litigation advancing disparate impact claims. That is obviously a meaningful enforcement change for employers at the federal level. That plan affects the kinds of cases that the EEOC is going to investigate and litigate. So it's a big shift from the way the EEOC has viewed disparate impact in matters in the past. Typically, the EEOC prioritizes cases of systemic discrimination that often rely on statistical evidence. But remember that an executive order doesn't affect or repeal a federal statute, and that an agency's enforcement plan doesn't bind or really affect private plaintiffs. So we still have Griggs as controlling precedent, and the courts are going to decide the cases that come before them based on existing statutes and existing judicial authority, not necessarily or not solely based on the current administration's litigation priorities or interpretations of the law. So I think for employers, the biggest takeaway from this shift by the Trump administration is not that nothing has changed, because it obviously has. The federal enforcement risk has changed significantly, but it's that not all disparate impact risk has just magically disappeared. So I think you'll see that as we continue. And again, in alignment with the president's executive order, the EEOC sought a formal legal opinion from the Department of Justice regarding its existing guidance to employers on disparate impact theory. So last month, the Department of Justice's Office of Legal Counsel issued an opinion concluding that the EEOC's existing interpretation of Title VII's disparate impact theory is unconstitutional. The opinion reasons that the EEOC's framework pressures employers to make race-conscious decisions to avoid statistical disparities. And in the DOJ's view, that pressure conflicts with equal protection principles and is encouraging employers to put their proverbial thumb on the scales to drive specific race-based outcomes. And, that constitutional tension really isn't new. You might remember the Ricci versus DiStefano case from, I looked it up, 2009. Seems hard to believe that it was that long ago. But there, the Supreme Court considered an employer's decision to decertify firefighter promotion test results because of the disparate impact it had on Black candidates. And after the city threw out the test, white and Hispanic firefighters who had scored well sued the city for disparate treatment discrimination. They said, you threw out the test based on race. And ultimately, the court held that an employer needed a strong basis in evidence. That was the standard created by the Supreme Court, a strong basis in evidence to believe that it would otherwise face disparate impact liability before making race-conscious actions based on test results, such as in that case. So the Ricci case was important to the DOJ's opinion and assessment because it kind of highlights the employer's dilemma between these two theories. If an employer ignores a clear disparity, then it might face a disparate impact claim. But if it changes a decision or practice because of disparities, then it might face disparate treatment claims. So the DOJ's position is that it's not appropriate to manipulate outcomes to achieve a preferred result based on race, but to just have fair processes in the first place. The DOJ opinion goes on to propose corrections to the EEOC standard for evaluating Title VII disparate impact claims. And it's important to remember that, the DOJ they're stuck with what Title VII actually says because it can't rewrite the statute, but it made these suggestions to how the statute should be interpreted. And the first step, I don't really think made much of a change, but they called the causation analysis to be more robust, that there should be a more robust causation requirement, and a plaintiff has to show that the challenge practice is connected to the disparity. I think that's already part of what Title VII says. Second, this is more of a change here in interpretation. And the DOJ says that the employer's justification for the practice should be satisfied if it can articulate a basic rational business purpose. And that should end the inquiry, which would be a less demanding standard than we have now with the traditional job-related and consistent with business necessity standard. Would really, I think, give employers more latitude in defending their practices. And then third, the final step here, the Department of Justice would again require the plaintiff to identify an equally effective alternative that would eliminate or reduce the disparate impact, and that would still be as effective in serving the employer's legitimate business interests. So it tightens up that alternative requirement just a little bit. So I don't think it's a wholesale rewriting of the EEOC's existing standards, but I do think it's making a little bit more employer friendly, a little bit harder for plaintiffs to get through some of their hurdles. And this brings us to the practical distinctions here. What does the opinion change today, and what isn't changed? What remains in effect? So what does the DOJ opinion do? It does state the administration's legal position around the disparate impact theory. It gives federal agencies a roadmap for revisiting their existing guidance and rules. It invites them to seek changes. It also supplies arguments to employers and litigants that they can use in court and cite to the Department of Justice's official opinion. With respect to seeking changes to existing guidance, the EEOC, in response to the DOJ opinion, did or has proposed rescinding the uniform guidelines on employee selection procedures. So that is currently pending. It's just a proposed rule at this point, so the guidance has not yet been rescinded. And it's just the EEOC that has made that proposal at this point. You'll recall I mentioned it's been adopted by other federal agencies. I am not aware of any other federal agency proposing to withdraw or eliminate that guidance from their framework. What does the DOJ opinion not do? It does not remove disparate impact liability from Title VII. Doesn't change Title VII. Only Congress can do that. It does not overrule Supreme Court precedent. It does not bind state courts that are interpreting their own independent state statutes. And it certainly doesn't eliminate private rights or causes of action under Title VII. And even if the uniform guidelines do go away, based on the EEOC's proposal, it still won't end disparate impact concerns. It will eliminate that framework, the guidance that employers have relied on and used for decades in their own internal assessments and evaluations. But again, disparate impact liability is still part of Title VII. In this next section, we are going to look at the state layer of disparate impact liability. So many employers obviously operate in a lot of jurisdictions. So in addition to federal law, we have many state and localities that recognize disparate impact through either statute, regulations, or judicial interpretations. And state statutes may also protect demographic categories that aren't covered by federal law. They can have different burdens or frameworks for assessing or analyzing disparate impact claims. They might offer different remedies. They could offer enforcement through a state civil rights agency as well as, or instead of a private right of action. So for a multi-state employer, like most companies are, this means that the relevant question isn't just, okay, what is the EEOC going to do? It goes much further than that. And the questions become things like, well, where is the employee or applicant located? Where is the decision being made? Which law or laws is going to apply to that decision? Which regulator can enforce that law? Where can a private plaintiff bring a claim? So the list can really go on and on regarding the questions that employers have to deal with in this state-by-state analysis or assessment. And I think employers that are looking to establish a single national process will want to meet the most demanding applicable requirements. I prepared a map that illustrates kind of why the state analysis has to be done jurisdiction by jurisdiction. It really is all over the map. But the colored categories here provide a general overview of existing state laws addressing disparate impact in employment. So we have the blue states that expressly prohibit practices in employment with a disparate impact. So that's in their statute or regulations. The red states have acknowledged or allow a theory of disparate impact through their courts and statutory interpretation. So it might not be written in the statute, but the court said, we're going to interpret our law, our state law, to include a claim for disparate impact. And then the gray states don't seem to address disparate impact. The topic you all have been waiting for, I know, is disparate impact and artificial intelligence. This is really the most active area for disparate impact now, with the proliferation of automated systems in employment. So let's turn to AI in the employment process. And the main risk with AI and disparate impact liability comes from the many, many places that an automated system can enter the employment life cycle. We have AI tools that can influence sourcing and resume screening, candidate ranking, evaluating or analyzing our interviews of candidates, our assessments of candidates, performance evaluations, workforce planning, reductions in force. Really, these models can affect, it's not just who gets hired, but who gets training, who gets certain shifts, who gets a promotion, who gets let go during a reduction in force. All of these types of employment actions that can be covered by Title VII and state law that are considered to be a term or condition of employment. And disparities from these systems can be created or can occur in a variety of different ways. Sometimes we are using historical data that is reproducing patterns from earlier decisions that might not be bias-free, or they might have had been impacted by disparate disparate impact. For example, we could be using a variable such as past performance ratings that could import prior biases or inconsistencies. An assessment can certainly create disability concerns if accommodations are not considered in the process. A model can evolve over time after we've been using it, after it's been deployed, as we have more and more applicants, more and more decisions are made, job requirements change, our data sources, our variables change, the model is going to evolve as well. So all of these things can impact how disparities are created. There are some states that already have AI laws that address disparate impact, but they're few and far between from what we can tell thus far. And I think only one state, I think Illinois, is the only state that's actually enacted a law that explicitly prohibits the use of AI in employment decision-making that has a disparate impact. The other states that are listed here, it's either come through regulatory interpretation. I think that's generally the case. I know New Jersey doesn't have an AI-specific employment statute, but their Division of Civil Rights has issued guidance clarifying that the New Jersey law against discrimination applies to algorithmic discrimination caused by AI tools. I think the same is true for California. They've addressed it through a regulatory action. And of course, the states that have proposed legislation, this is changing constantly, and I think will continue to grow. So I think we will see more states appear on both sides of this slide in the near future. Definitely something that you have to keep up with on a regular, consistent basis. All right, with that in mind, let's look at our practical takeaways. What can we expect to develop? What should employers do now? I think the safest prediction for employers is continued uncertainty on the federal level and increasing regulation on the state level. I don't think it would take, anyone with special expertise to figure that out based on what we're seeing. But that's certainly what I would suggest the tea leaves, how the tea leaves are being read. The federal agencies are clearly moving away from disparate impact enforcement, and the states are expanding civil rights and their AI governance requirements. And one thing to keep in mind, we're talking about the federal administration. This is the Trump administration. There's 2.5 years or so left in the Trump administration. Way too early to predict what could happen after that. But certainly, the next administration, whether it's Republican or Democrat, could go in a different direction. So that's one of the problems that employers often face, is kind of the shifting winds in Washington and what any current administration elects to do on a policy basis. So just because this administration has chosen to deprioritize disparate impact does not mean that the next administration will do the same. I think we should also expect greater scrutiny of our employment data. With AI, I think we're going to have better data, theoretically at least, and the tools we're using, the AI tools and decision-making systems, should make it easier to calculate the selection rates at various stages in our process. I'm sure there are tools that even build that in and make it part of the decision-making protocol. But at the same time, we have to remember that we can't just rely on the raw data. Go back to our hypothetical at the beginning. We have to typically dig deep into the data used in our disparate impact analysis to ensure that it's really valid for investigating potential disparities. Often the numbers used in the analysis are not, they're just the beginning point, not the ending point. There are many ways that employers need to investigate to be sure we are looking at the right data. And again, it goes back to in our initial assessment, our initial example, the applicant pool. We had 100 females in that applicant pool where we hired the 5 women. Well, were all 100 of those women qualified? How many of them withdrew from the process? They learned more about the job and they realized that's not the job for me. I withdraw from the process. How many were excluded for other legitimate reasons? So it's that deep dive into the data is always going to be necessary. And then I suspect that a Supreme Court decision around disparate impact will be in our future someday. We've got this tension. I think the Department of Justice is setting this up for a potential Supreme Court case in the future. I'm not aware of any case that's currently in queue or on appeal to the Supreme Court, but the constitutional arguments that the DOJ raises may eventually reach the Supreme Court. And again, as we know, it's the Supreme Court that interprets what Title VII means. So we're kind of in that, as I said, the uncertainty at the federal level until we get more or get clear guidance from the Supreme Court. And I suggest that the strategic response for employers to all of this uncertainty is really to keep our options open and to retain the best practices that we've been using for years. So we want to make sure that we're using criteria that is reasonably related to the job when we're making selection decisions. We want to know where disparities exist and to investigate when that occurs to determine what's causing it, and do adjustments need to be made. And we also need to have the evidence that will support those legitimate business decisions and our defenses to disparate impact claims. This slide is a reminder that disparate impact analysis is not confined to Title VII. Title VII covers race, color, religion, sex, and national origin, but disparate impact claims also can arise under the ADEA, the ADA, and of course, state laws. Under the ADA, disparate impact protects, well, the statute protects workers who are 40 or older, and an employer can defend a practice that has a disparate impact on that age group by showing that it's based on reasonable factors other than age. So it's a little bit different standard than what we see in Title VII. The ADA prohibits an employer from using qualification standards, employment tests, or other selection criteria that screen out or tend to screen out an individual with a disability or a class of individuals with disabilities unless that standard or test is shown to be job-related and consistent with business necessity. And of course, we also have accommodation issues, accessibility issues under the ADA. So those are other ways that disparate impact can be raised in addition to our traditional race and sex analyses. And of course, as we discussed, state law can also come into play for disparate impact. State laws can cover additional demographic characteristics. They might have different causation standards or burdens, different remedies. And so that's another reason why we're doing a disparate impact analysis. We might not want to just limit ourselves to race and sex if we have additional information related to characteristics that are covered by a statute. I thought this would be helpful information as well. How are courts currently applying the disparate impact theory? Um, so far, and of course, it's too soon to see if courts are going to change or how they might change their application of the Title VII standards based on the Department of Justice opinion. So it's kind of theoretical at this point, but we are seeing that despite the federal policy that's been in place for over a year, courts are still analyzing disparate impact claims under existing law. And so we've got a few fairly recent cases here that illustrate how it's being used in different stages of litigation. In this first case, the Bomar versus Board of Education, this came out of the Fourth Circuit, I think just a few months ago. But in this case, the plaintiffs were Black women over 40 who challenged a variety of things, but the main thing as relevant to the disparate impact theory was a reassignment process that was connected to a reduction in force. And the court ultimately affirmed the summary judgment for the employer, where the plaintiffs did not propose that alternative practice to the practice that the board used. So they didn't show what else the board could have done that would have had less of an impact, but still serve their legitimate business purposes. The Mobley versus Workday case, it's been around for a couple years now, but this is also a case based on alleged discrimination by an algorithmic-based applicant screening tool that Workday deployed for various employers. And we're still in the very early stages of this case, but the court denied the motion to dismiss disparate impact claims under Title VII, the ADEA, and the ADA, based on the alleged disproportionate impact on those protected groups. This is a reminder that an employer's defense to a claim of disparate impact discrimination will rely heavily on data and information that the employer has. So this brings us to, I think, a new and current debate around whether employers should continue to solicit race and sex information from their applicants and employees. And I know a lot of employers that weren't federal contractors have not necessarily been soliciting race and sex information from their applicants. But under the uniform guidelines and under Title VII disparate impact liability, those are at least arguably records that employers should have to know whether or not their practices do create disparate impact. But many employers are looking at this now. You know, if the EEOC is going to rescind the uniform guidelines, they're going to rescind, or they propose to rescind, our EEO1 reporting requirements. Should we still collect this information? I think it's a very valid question. And I also don't necessarily think there's a single answer for every organization, but I would be a little cautious about stopping the collection of and voluntarily or soliciting the voluntary information from our applicants' employees just because of the federal enforcement priority change. Again, we still know that Title VII contains disparate impact liability. Without having this information, an employer is going to be hard pressed to evaluate their selection processes to see if there's an adverse impact. Might be hard pressed to defend claims alleging a disparate impact if it doesn't have the data to show how individuals were impacted. And I will admit, it's a little bit of a double-edged sword, because without the data, how is the plaintiff going to bring that type of claim as well? I think there are ways that a plaintiff will get around that. There's census information. They can come up with, I think, other ways to, creatively make that argument. So again, I think it's something that organizations need to really evaluate critically before eliminating their data collection. But at this point, it's not an easy answer, but another important factor are the state requirements. If you are a California employer or an Illinois employer, those states are currently requiring covered employers to submit information regarding their workforce demographics. California is the equal pay data report, and Illinois, again, companies are required to, I think it's every other year, submit information on their workforce demographics. So I think employers just need to take a step back and do an assessment of existing state requirements and what data is needed to comply with those. And then I have 5 action items that hopefully employers can take away without necessarily waiting for the law on the federal level to kind of settle down. The first is that I think employers should remain mindful of disparate impact liability, especially in those states that already recognize the theory of disparate impact or regulate automated employment decisions. Second, I think employers should continue evaluating their selection procedures, especially those that are determined using artificial intelligence. If a disparity appears, it should be investigated, determine what's causing it, and whether or not there's an alternative that could be used if that's appropriate. Definitely for those employers that are using automated employment decision tools through a vendor, look at those contracts. You want to make sure that you have the right to audit the data, see how they've been validated. You want to make sure you have notice about changes that they're making to the model, how they're storing and retaining data that you might need, that they'll cooperate with you should there be a charge or litigation. So lots of things, obviously indemnification provisions, but lots of things that I think companies want to review in their vendor contracts. Also want to monitor state and local AI developments, determine, do we have to conduct a bias audit in this jurisdiction? Do we have a notice duty? Do we have to put notice? Do we have to put our applicants and employees on notice that we're using an AI tool? Are there other substantive requirements that we face? And then finally, of course, I have to say that you should consult your employment lawyer early and often, at least early enough to help shape your process. It's always best to get some practical advice around employment decision tools before you implement them and affect thousands of applicants or employees. So I've got a couple minutes left. I'm going to scoot through this. I know you want your credits, which are on the next slide, but I did want to specifically recognize Robert Santos, who is a law clerk with us this summer in our Princeton, New Jersey office. He provided very significant assistance on the analysis of the state laws. So happy to have him, and thanks to him for helping out with that. Here are your codes for SHRM and HRCI credit. And then I am going to switch to the chat to see if there's anything. I answered that one. Yes, again, the presentation, the video, as well as the PowerPoint will be provided. Thank you for the compliment. I don't see any other questions here, but you'll get the email from Victoria Brown with the slides, with the link to the video. It will have my contact information, so certainly feel free to reach out. And extra bonus materials, I just did a bulletin basically on this topic. So if you feel this wasn't quite a deep enough dive, you can check our bulletin out as well for some additional resources. But thank you so much for joining us today. I hope this was helpful. Let me know if you need anything else, and enjoy the rest of your day. Thank you.